Good morning, good afternoon. Thank you everyone for joining us as we wrap our final day of our virtual design market. My name is Risa Eldon and I'm the head of industry partnerships here at House. We just launched House Pro, which offers an all-in-one solution that empowers home design and renovation professionals to stand out, win more clients, increase profits, get paid faster, and stay connected with your clients and teams. And we're here today as part of, I would say, round two with Jardim and Scott Salmon, employment lawyers based out of New Jersey, to cover what you need to do right now to protect yourself and also when you re-enter your job sites. So if you missed round one, I can always send you that recording, but today we're really going to hone in and focus on procedures for reopening your business, keeping your employees and clients safe, and how to make sure any loan money received under the PPP is forgiven. So without further ado, I'm going to pass it over to Tom and Scott because I know we have a lot of stuff to get through today. And if you have questions, just go ahead and pop them into the question box and we'll make sure to get to all of your questions.
Okay, thanks so much. I'm Tom Jardim. I'm a partner at Jardim, Meisner & Susser in New Jersey, and my partner Scott Salmon is also here, and we're going to talk about exactly what Risa just said. So really what we're going to talk about, we were with you a couple weeks ago to talk about hopefully how to take advantage of some of the federal stimulus programs and how to deal with your businesses that closed or went virtual. Today, we're going to be talking about reopening, or at least planning for reopening. And it's really the when, which, and the how. So when can your business open back up again? And Scott is going to address that. Which employees do you bring back? And how do you actually reopen your business? And I'm going to address that section, and then we'll address some FAQs and take any questions that you have. So I'm going to throw it over to Scott so he can begin.
Thank you, Tom. Okay, so the short answer to when can you reopen is that we don't actually know. Every state is moving at its own speed and deciding how exactly they want to do this themselves. And they're each going to be deciding if it's going to happen in phases or all at once, and when exactly, that's all we're in debate. There are some general rules regardless of what exactly the states do, things that you're going to have to keep in mind, and Tom's going to go into a lot more detail about this. But the general guidelines for when you can and what you can do when you can reopen is you should be implementing social distancing, if possible, providing PPE to your employees. We'll discuss temperature checks and sanitation and things like that later on. Federally, the government has announced this. It's called the Opening Up America Again plan. It's a 3-phase program, although it's going to again happen on a state-by-state basis in conjunction with each state's governor and what exactly the situation is on the ground there. Generally speaking, they're going to still be encouraging people to telework when possible. They want you to, if you have a physical business, they want you to minimize non-essential traffic. If you have common areas, to limit access to those common areas, as well as sanitizing them as much as possible, and as well as providing special accommodations to people who are particularly vulnerable to COVID-19. It's, I think, pretty widely accepted now that there will be, at least to some degree, some sort of second wave of people who become infected with it as we return to work. And so with that in mind, when this does happen, the government's going to be asking you to make special accommodations for people who are most likely to get it. So
Scott,
I wanted to
can I interrupt you for a second? Do you have headphones next to you? You sound okay, but like a little bit far away from us. Do you have headphones, or can you turn your volume up a little bit? If you don't, it's okay.
Does it sound any better?
I think that's a little bit better. Yeah.
Okay.
Or, yeah, just a little bit, maybe louder in your tone. Yeah.
Okay, fair enough. Speaking louder has never been a problem for me. So, okay, so let's talk about I was just talking about reopening states. You can see here on the screen, this is from the New York Times. There are a number of states that have already started to have some sort of partial reopening. I know Georgia has gotten the most attention for this, but there are obviously a couple other states as well. There are a number of states that are, as of tomorrow, their stay-at-home orders are going to be expiring. And frankly, for a lot of these states, we don't know exactly what they're going to be doing until probably tomorrow. Honestly, I'm expecting a big wave of extensions here of the stay-at-home order. So your state, if you're appearing as the light yellow here, you may not actually be reopening tomorrow. And then for the majority of the states, bulk of them, they are continue to be shut down. Their orders have extended. So this is for those, especially, we're really just planning on what happens when eventually in the next few months they decide to reopen. So let's talk about which employees you can bring back once you start once you start not either rehiring or bringing people back into the physical workplace. And as part of this, we're going to discuss the Paycheck Protection Program, and if you receive money under there, how to get your loan forgiven. But let's just start generally here. When you are bringing back employees, you may have been able to keep all your employees, if you have them, on the payroll. If you already have a work from home, work remote policy in place that you've been using for the last month or two, it's probably a good idea for you to either continue allowing people to do that to the extent possible, or either, if you don't have one already, to create some sort of policy like that. If you are rehiring employees, let's say you let someone go because you couldn't afford to keep them on the payroll for the last month or two, and so you let some people go, it is incredibly important that when you actually are deciding who you are bringing back, that you not do so in any way that could be legally construed as discriminatory. If you do, you'll be opening yourselves up, and I think Tom's going to cover this a little more. You'll be opening yourself up to some liability if you are picking and choosing who you're bringing back based on some physical attribute or something else like that. And just generally speaking, it's good for you to be cognizant of concerns by employees, even if your state is reopened, and they may still be cautious about actually physically coming back to your office or going to client locations or things like that. Generally speaking, they probably have a good reason to be at least cautious about it. And so even if you are allowed to require someone to, if you can require someone to come back and they're expressing concerns, it's still generally a good idea to be cognizant of that. How's this going? Is it better? Is the volume better?
Yeah.
Okay, good. Okay, so let's talk about the Paycheck Protection Program. This is only applicable if you've received money from the PPP, or you've applied and you're waiting to hear back. Maybe you've been accepted, but you haven't actually gotten the money yet. In either case, would imagine that you want to have that money forgiven, so you don't actually have to pay it back to the government. That would be great. The one really nice thing about one of the nice things about the PPP is that for its forgiveness is that it's not all or nothing. It's not all of your money gets forgiven or none of it does. It's a sliding scale, so it's possible that you may have to repay some of it, although realistically, as I'll explain, it's probably not going to be very much. But it gives you some leeway. It doesn't require absolute perfect compliance to at least get the vast majority of your money forgiven. So that's good. So what they are looking at, and when I say they, I mean the bank, so the bank that is giving you the money, is they are looking at the 8-week period following when you actually physically get the money dropped into your bank account, and they're looking at the 8 weeks following that. And so they're looking to see that you are spending your money, the money that you received, on, first and foremost, it's called the Paycheck Protection Program for a reason. They want you to spend it first on the 8 weeks of payroll and bring back employees, people who have been either let go or their hours reduced between February 15th and April 26th. You want to make sure that those people are brought back going forward and put back on the payroll. So the main part of this the forgiveness is, like I said, the payroll costs, but they're going to be looking at all the costs that all the things that you've been spending your money on. You can't spend more than 25% of the total amount that they give you on non-payroll things, so you can't spend all of it on, well, let me phrase it. You can spend all of it on, let's say, your rent or your utilities or whatever you want, you just won't get it forgiven. So if you want to have the money forgiven, though, you 75% of it has to go to payroll, and then at least 75% of it has to go to payroll, and no more than 25% can go towards other things like mortgage interest, rent, utilities. Loan forgiveness is also reduced by if you received an advance under the Economic Injury Disaster Loan Program. We discussed last time that it's up to $10,000. Since we did that, the SBA revised that, and they made it so it's $1,000 per employee for the first 10 employees with a cap of 10,000. So if you have one employee, you get $1,000. If you have 10, if you have 20, you get 10,000. That amount gets reduced from the loan forgiveness total. In effect, they're trying to avoid businesses from double dipping on the free money. So if, let's say, you got $100,000 under the PPP, I'm just making up numbers here, and you got the full $10,000 advance, and you have the full $100,000 would otherwise be totally forgiven. It's actually going to be $90,000 that gets forgiven. It's going to reduce it by the amount of the EIDL advance that you received, and that amount, that balance is what's going to have to be repaid. Now there is I want to say it's a complicated formula, but it does require some thought and some actual math into figuring out how exactly how much of your money is actually going to be forgiven. It's based on two things. You're bringing back your employees and restoring them to the compensation that they were making previously, if their wages were reduced or if they were just let go. And so they will look at those two things. Your what's called full-time equivalent employees. So if, let's say, you let someone go and for whatever reason you don't want to bring that person back, but you decide to bring someone else back in their place, they're the equivalent of that. If you're replacing their wages, let's say with part-timers, you have a couple of them and they have the rough equivalent of being your former employee, then that's a full-time equivalent. So they're going to essentially compare who you had before and who you have now over the course of that 8-week period. And so the formulas on here, I don't think I really need to go into detail on the math of how this works. But like I said, they're going to be looking at the number of employees you have during the period, as well as how many you had before then. They're going to divide them and they're going to come up with a number. Ideally, the division shows the number 1, because that means that you've replaced everyone or you've brought everyone back, and that number gets multiplied by your total loan amount. So if it's 1, it's 100%, you get the entire amount forgiven, but it could be reduced from there. Same thing for wages. Similar thing for wages. If you let's say you bring everyone back, or you never let anyone go, but you only restore them to, let's say, 50% of what they were making before, they're going to compare how much the employees are making during this cover period and compare it to what they were making beforehand. And they'll if it's lower, then they will reduce the forgiveness amount by that. Okay. Now, if your money is not forgiven, your PPP money is not forgiven, what does that mean? Like you said, you have to repay that. It's a 2-year loan at 1% interest rate. You don't have to pay anything for the first 6 months, but you could choose to if you want. There's no prepayment penalty or anything like that. So let's say you are a sole proprietor, which I imagine a lot of you are. You are going to get you're going to get you could take out money for your own compensation, and let's say there's something left that doesn't reimburse you for those 8 weeks, because obviously it's going to cover more than those 8 weeks. And let's say you don't have any rent, you don't have any utilities, you just have this money sitting around, and you don't want to have to pay it back, plus interest. You could just pretty much immediately pay it back, and you shouldn't be on the hook for any interest. But you could do that pretty much immediately in that 6-month period before you actually start accruing the interest, before the loan's actually due. For what you're going to have to show to the bank to get the money forgiven, you're basically going to have to show them your records. You're going to have to show them your actual, if you have a payroll processing service or provider, you can show them those records, and that will show them both number of employees as well as how much people are being paid. If you're a sole proprietor, you're going to show them if you have any financial statements or any bank records, Basically, I'll say anything more complicated than the actual straight printout from the bank of what your transactions were. Anything slightly more complicated than that is probably going to be enough. The SBA has given the banks extremely wide, I guess, berth to approve these the loan forgiveness. They really want to allow as many people to have as much forgiveness as possible. The expectation when they gave out this money was that they were never going to see any of it back. So the banks, they're not really, aside from what you give them, they're not really required to do much verification. They shouldn't really be, I'll say, pressing you for detailed, extensive records of everything. So basically everything above just your transaction history from your bank account should be enough. Some banks will be a little more demanding than others, but generally speaking, they're not really required to ask for all that much, except for just enough on the face of it to show that you use the money for what you're supposed to.
Got it. I have a question from the audience coming in. I was refused unemployment as a contractor. I own my own business as a sole employee and no clients, and have no clients during the pandemic. Can I apply for a loan to pay my own salary?
Yes, if you can get I'll say if you can get a bank that will process your application. Right now, I don't believe they're out yet of money for the second round of PPP funding, but they almost all of it is spoken for, and most of the holdup has just been that the banks have been having some technical issues with actually submitting applications. So if you can get an application in, and then I would say yes. But with that said, I would need to know more about the specific situation, but you probably should not have been denied for unemployment if you're 1099 independent contractor. You probably should not have been. There are a number of states that have been, this is a very stupid process, but there have been a lot of states that have essentially required you to get rejected and then for you to reapply, even though you've just been rejected, to actually get the money. And the reason those states do it that way is because technically you may not qualify for unemployment under normal times because you're an independent contractor, but because the government has created this pandemic unemployment assistance program, you technically have to reapply for that once you've already been rejected. So that may be what's going on in this specific example. So if it was me, I would reach out to the unemployment office again, find out if there's anything else you need to apply for to get the federal pandemic assistance, because you should again, I don't know the exact situation here, but you should be entitled to the $600 a week amount from the federal government.
Okay.
Good. Okay. So with that, I'm going to turn it over to Tom now.
Great.
Tom?
Right, yeah, I'm here.
We don't need your sign? Don't worry.
No,
I have it right from last week or 2 weeks ago. Just kidding.
actually,
wait, really quickly before you go ahead, somebody in the thread that's also in our private Facebook group mentioned that they posted a link this morning for a small bank matching service for PPP that worked for me and another one of our designers. If anyone is looking for a place to get in their app quickly, can you post that link in the chat right now if you have that, or I can try to copy and paste it? That's really helpful. I have from round one of the PPP heard, a lot of frustrations, a very limited amount of, small business owners, designers, architects, builders got that money. And I know there was round two that was opened up. So that is really helpful information.
Yeah.
And then another one, I think we'll cover this about reopening. I just want to make sure that we will cover it because she's asked twice here, is about signing a waiver for people entering job sites. Do you need to have a document? I know one of our designers again posted something and it was like, what to expect when entering the job site. Let's just make sure we cover that, Tom, when we go through.
Yeah, we'll do that in the FAQ.
Cool.
Yeah, we'll do that in the FAQ. And I just wanted to sort of go over one thing that Scott said about the PPP monies going out and the government not expecting them to come back. The only exception to that is there was some new guidance put out yesterday by the SBA, really geared towards big businesses. So probably people have read that like Shake Shack and the LA Lakers have gotten these PPP loans. So the SBA put out some guidance that said, listen, we're giving you this money, but you still have to certify in good faith that the PPP loan request is necessary for your financial bottom line, and that you can certify that current economic uncertainty makes the loan request necessary for your business operations. So if you've gotten a loan, you're still going to need to be able to certify that that's true. So just a note there. All right, and then Scott, you want to go to? Oh, sorry, you are there. So I'm going to cover the how, as in how to reopen. This might seem a little. I will say that my own law firm, we're looking, or I'm optimistically targeting Monday, May 18th. I don't know if that date's actually going to happen, but we're starting to plan for that, and I hope it will actually. So the bottom line on that how is you're not going to have liability if you comply with your state's executive orders and whatever federal orders there are out there, as long as you comply with that. The only exception to that is you still have to comply with federal and state OSHA obligations, the federal regulations and laws that apply to workplace safety. So you want to go to the next slide. All right, so OSHA is this law. Everybody's probably sort of heard of it. Maybe don't know too much about it. Even lawyers who specialize in employment law don't seem to really know much about it. It's kind of a boring thing for employment lawyers. And you know, most of us think it doesn't really apply to us. It's for factories and things like that. And generally that's true. But this is one time in which we are all business owners are going to have to pay attention to OSHA. So what is OSHA briefly? It's the Occupational Safety and Health Administration Act. It was signed into law in 1970, so this is its 50th year. It essentially sets and enforces workplace safety and health standards. It is mostly geared towards larger employees, towards industrial operations, towards manufacturing operations. And so there's a host of responsibilities that apply to those type of activities, including in particular injury and accident reporting, as well as OSHA inspections. However, oh, and in addition to that, Scott, next slide. So with businesses of 10 or fewer employees, you're exempt from most of OSHA's requirements, most of the record keeping and the reporting requirements, in addition to the program inspections that occurs by OSHA workers. And also, if you have more than 10 employees, but you're in particular industries categorized as low hazard industries, then you're also exempt from most of the requirements of OSHA. So that's where this NAICS stuff comes in. Every industry type is identified as a particular type of business. Architectural, engineer, and related services is a 5413 NAICS code, and interior design and specialized design services is a 4471 code. So those businesses, law firms as well, are identified as low hazard industries. That might be a subject of opinion, but in any event, those industries that are identified as low hazard are not subject to most of the reporting and record keeping requirements. However, regardless of your size of employer and the type of employment that you are in terms of low hazard, all employers are subject to OSHA's general duty clause. So Scott, next slide. So the general duty clause in OSHA basically says every employer shall furnish to its employees an employment and a place of employment which is free from recognized hazards that will likely cause death or serious physical harm. So what's a recognized hazard? It's generally defined in the statute and in the regulations. relates to your particular industry of the employer, but it's also defined by common sense, which is why it comes into play here. Next slide. So every employer has to satisfy the requirements of the general duty clause under OSHA. And in order to do that, every employer has to take undertake a hazard identification analysis, basically to identify whatever steps they need to identify in order to reduce the risk of harm. And here the harm obviously is exposure to COVID-19. So the hazard analysis, according to OSHA, involves 3 steps. Identify the workers that are at high risk, identify the potential sources of exposure, and identify any appropriate control measures that you should take in order to eliminate or mitigate that exposure. Next slide. Okay, so to do this hazard identification analysis, employers are or should develop an infectious disease preparedness and response plan. This has been in existence for a very long time. Mostly it applies to large employers, and universities have done these types of plans for years. It's basically a roadmap for what we're going through right now. What's coming and what you need to do to reopen your business. So this thing, which was heretofore a little bit, not very common for employers to have. I suppose we always say, yes, we want to have an emergency response plan as employers. Just mark my words on this. After this, as a result of this, every business is going to have an infectious disease preparedness and response plan. They will be as ubiquitous and as often recommended by employment lawyers as employment manuals are today. So you're going to need to put one together in order to reopen, or at least you should. So, and I just want to say that again, do not open up your business again, your work site, without having something in writing that you've given some thought to and that you've clearly communicated to your employees. Every office, no matter what the size, should have one of these going forward. Obviously, every office is unique, and so every plan is going to be unique, but there are definitely going to be common elements in each one. All right, so what are you going to address in these plans? At a minimum, you're going to follow whatever federal, state, and local recommendations there are. But OSHA has set forth some guidelines as to what should be included in these plans, specifically related to COVID-19. The need for social distancing, any staggered work shifts, downsizing operations, what to do with deliveries to your office, other measures to reduce exposure, particularly going into other work sites in which your workers may be exposed. You have to include that in your plan. And other recommendations, conducting essential operations from home, using different job locations, dealing with supply chains and deliveries and that sort of thing. Next slide. So in March, when this all started happening, OSHA issued something called Guidance on Preparing Workplaces for COVID-19. This was at the front end of the crisis. This report, and you see the site there, you can access it. It basically lays out what an infectious disease preparedness and response plan should have in it. Yeah, Scott mentions here in the slide that you should or you can hire an attorney. I know Scott doesn't want me to mention another resource, but I will. It's Cushman & Wakefield, which is the commercial real estate services firm. They've prepared a very, very good document called Recovery Readiness, a how-to guide for reopening your workplace. And essentially it lays out all the things you'll need to consider. It basically plays off of the OSHA guidance that was issued in March, but does it in terms that are a little easier to understand. Just
Tom,
like—
can I stop you for a second? Because there's
Sure.
a lot of questions coming in about this, and it might all be the same question. OSHA is only for employees, right? Do I need an ID PRP if it's just me?
And you as the owner are an employee, I would still recommend it, to be candid with you. It will give you, just like an employment manual, it will give you liability protection should anything happen. And I'll go into that in a little bit. But yeah, just like an employment manual, you should have it, even if there's only one employee, and it plans for the future as well. All right, so an infectious disease preparedness and response plan. It's basically a common sense plan, including the stuff we already know. Wash your hands, social distance, spray down, sanitize the work site. At a minimum, you should be having a written plan that sets forth a contingency for reclosing when the likely surge of COVID-19 comes back, unfortunately. You need to have in that written plan actions to take if one of your employees gets sick. All the social distancing rules. That Cushman and Wakefield document that I mentioned actually has a video attached with it that lays out, sort of how to lay out your office, just like at the supermarket. You could put tape on the floor to tell people how to walk, which way to walk, so they don't pass each other. But all the other things, and again, it's unique to your own business, all the other things that you'll need to think about in your plan: staggering of work shifts, the delivery services to the receptionist, and that sort of thing. I never thought this would be the case, but you may find yourself buying personal protective equipment for your employees. That's one of the things that you may be required to do under a plan, particularly for your reception people. Okay, next slide.
So really quickly, just clarifying, a lot of questions here coming in about OSHA.
Yeah.
What about my subs? It's just me and them.
Subs in the office?
I think she means, meant actually before when you were talking about
So like you're talking to the lawyer, when you ask the lawyer, should you have a plan even though you're one employee, I'm going to say yes, because it's a conservative thing to do. But I recognize that if it's only you and, there's not a big difference between working in your office or working in your kitchen, you probably don't need one, but it's a good idea to have one.
And I think she might have meant, what about my subs on the job site? It's just me and them. And this question actually came into here. Also, I want to know if my employees are non-essential, can I ask them to have one person in the studio at a time, or do I need to keep them home?
Can you repeat that question?
Yeah. If my designers or employees are non-essential, can I ask them to have one person in the studio at a time, or do I need to keep them home?
This may, at least for right now, it's going to depend at least in part on whether your state is open or not and what exactly the state's requiring.
Right.
Yeah, we're going to go into it in a little bit. We'll go into more about when you can require someone to come to the office versus not. But I think for the thing maybe we say about the one person and the subs on the job site, I think at least I'm sure Tom would agree, but I would certainly say you should absolutely have something in that case, especially if you're going into a job site, place a foreign location that you may not control as well as an office. Then I would definitely have some sort of procedures or equipment or things like that in place for a situation like that.
Okay, got it.
Yeah. So, yeah, again, you can go to the next slide, Scott. I do want to say that, again, every work site is unique. So what's in your plan is going to be unique to your to your office. But I strongly recommend that you do not open up your work site without something in writing that you've given a little bit of thought to, and that you've clearly communicated to everybody. You know, I have one partner who's a little bit hard at times, and I have told him that now is the time to be empathetic, because and to give comfort to a certain extent. We have you know, one employee who's a germaphobe. We have in our kitchen the big thing with the big thing with pretzels with the peanut butter inside of it. I think we're going to have to get rid of that. But there's going to be a lot of concern that people have about whether they're going to want to come back into the office and what steps you've taken. And you really should set it down in writing, so that they have a clear understanding of what's expected of them and a clear understanding what you've done to make the workplace safe. So next slide. The sort of the lawyer liability thing here is OSHA is not going to be able to inspect every work site, even though they can under the general duty clause. Essentially, they say that they're going to be creating a spot check program to see that there's compliance with the general duty clause in response to COVID-19. We'll see what happens to that. I don't know if they have enough inspectors for that. But if you put together a plan in good faith and you give strong consideration to the safety of your employees, that'll be taken into account before you're issued any violation, you know, if you're inspected. And the converse is true to that. If you don't take any steps and you can't demonstrate any efforts to comply, you may very well be cited. So again, just like in an employment manual, having procedures to complain about sexual harassment and other types of illegal harassment, this is a defense for you. Put this document together and you can show good faith compliance. And along those lines, next slide, Scott, it would be a good idea once you put this document together to get your employees to sign and acknowledge it, just like you do with your employment manual. I know that I'm going
to interrupt you again. You just grazed over that or glazed over that. You said just like you do with your employment manual. What if people don't even have an employment manual?
Well, that's why Jardim, Meisner, and Sesser is here.
And not Wakefield and Cushman.
Yeah.
Right. I mean, as an employment lawyer, I would tell you, you should have an employment manual, and now you should definitely have an emergency response plan like this. You know, you may never have thought about it before. I've thought about it every once in a while. We should have our emergency response plan, but I've always laughed it off. You never maybe thought about actually having to buy personal protection equipment for your employees. Now you have to think about that. The bottom line point is communicate to your employees once you open back up. I'm looking forward mostly to, except for the part about putting real pants on, to opening back up on May 18th. I think we can in New Jersey. I think it's possible. I want to make sure that my employees know what's expected of them and what we've done to make the workplace safe. And we're obligated to do that by law. So there you go.
Okay. And then if I'm working with installers, do I need them to sign something before they work on my projects?
That are going onto a work site?
Yeah.
I would highly recommend a waiver of liability. Yes, and a document that sets forth additional things. Yes.
Okay.
Yeah.
And then
in fact,
this is an interesting question.
We recommended that to our employees, our clients as well, and prepared a form on that. So.
Yes. How do we get clients comfortable with getting trades out to our job sites? Are there certain protection measures we can use? And I think your previous slide covered that very clearly about staying 6 feet away, wearing masks. And somebody said, don't laugh, but do we need to be wearing hazmat suits? I mean, whatever you feel comfortable in and makes your client feel comfortable, right? Because at the end of the day, you are providing and going into somebody's home, and you need to have that confidence and that those measures put in place, the document that outlines. I've already seen emails from a couple designers that I follow. I'm on their email subscribe list, and they sent out a whole email today. Here's the measures that we're taking. Here's what we're going to do. If a client's sick, or if an employee is sick, they will not go on the job site. So lining out that document that Tom just mentioned, I think will cover that and make the client feel more comfortable.
Yeah, and I have a construction project that I'm involved with, and I've been a little bit surprised at this almost cavalier attitude of a lot of construction workers, at least in New Jersey, and this one project I'm involved with. So I think it's a good idea for designers to communicate to their subs what's expected of them. So if nothing else, that they have the ability to say, we asked them or made them do this, so we set it forth in writing, so please don't come after us if anything happens.
Great. Okay, and somebody just asked the same question again. Do I need to have my client sign a waiver if I'm meeting in their house? Yes, Tom said yes.
Yes.
We talked.
And again, you can do anything the client wants to in terms of virtual things, right? There's in New Jersey, there's a lot of virtual construction inspections now, believe it or not.
Yeah. The new normal. And then yesterday we had a session with a business insurance expert, and we talked about the hold harmless agreement. Is that a good document to use? Do you guys know about that?
Well, I don't know the specifics of the hold harmless agreement, but certainly it's a good document to use. That would be a waiver of liability and a hold harmless agreement. Yes. Now, whether or not it's going to be enforceable, that's a different story.
Got it.
In any particular situation.
Okay, we'll let you carry on, and we'll continue to ask questions as they come up.
Got it. All right, Scott, do you want to?
Sure. So let's cover some questions that I think we've definitely heard a lot, and there's a lot more detailed stuff. So there's some big questions, like, for example, what and some of the stuff you may have already dealt with at the beginning of this, you may also be dealing with it again, if like we said, if there really is a second wave and all those things. If an employee appears sick, if they're having difficulty breathing, it's a very good idea to send them home immediately. That's what's being recommended by the CDC. As well, if you have, depending on how many employees you have, if you have supervisors, you should train them, or at least talk to them about making sure that they don't immediately start running up and down that someone's sick. They're gonna get everyone else sick. Panic doesn't really help anybody here. There's been a significant increase, I'll say, in expansion by the Equal Employment Opportunity Commission, by the Department of Labor, the Federal Department of Labor, and by the CDC as to what you were allowed to do and what you were allowed to ask your employees in a pandemic like this, that things that you may not normally be able to do. So, for example, let's start with just here, that if someone has symptoms of COVID-19 or they're feeling ill, you're allowed to ask them to leave. You're allowed to ask them to stay home. It's not normally that may be discrimination against someone who has a disability, depending on what it is. But for right now, at least for COVID-19, you are allowed to do those things, whereas you may normally not be able to do those. And yeah, this is another really, really good example of something that you can now do that you couldn't do before. Whether or not you're allowed to take an employee's temperature at work to see, as a test to see if they might possibly be infected. This is not, I'll say it's not incredibly uncommon right now. That I've heard from a number of workplaces that they are essentially doing daily temperature checks when people come to the office or come to the workplace, just because it's not a guaranteed sign of whether someone has it or not, and obviously could have a temperature for other reasons. But there have been a number of places that have been doing this because it can be an early warning sign for COVID-19. And so normally there are a lot of restrictions on what you can do about either asking about an employee's medical status or what kind of essentially medical tests you can do on your employees. This is one that is now expressly allowed. Incredibly important note though, if you are in California, you are subject to what's called obviously we're not licensed in California, but I just know that this is a particular issue there. It may be as well in other states, so I would check your individual state. I just know that this is a particularly big thing in California. That if you're in California, you're subject to the California Consumer Privacy Act, which means that you have to provide them with your employees with a specific type of notice that's required under the law before you give them, let's say, give them a test, or before you ask them for information about their medical status. So, like I said, we're not licensed in California. I just know that in particular they're somewhat well known for having this. So if you're from there, that's something you should definitely consider and look into.
Scott, I have a California question. I know you're not licensed in California, but can an employee, again, in California, refuse to go to site checks if the property is empty and not near any clients, and the designer general contracting company provides masks and sanitizer? Can we terminate over that? Not that she would, but it could come up. Like
we're about to hit that in a minute, so let me just come right back to that. There's, I think, one more question before then. There's this one, I think maybe one more. One other thing that you're allowed to do now that you're not normally allowed to do is you can if you get, let's say you're hiring, you want to bring on new people, you're expanding for whatever reason, you can make people go on conditional job offers, and you can condition it on the fact that they don't have coronavirus. Normally that would probably be discrimination that would be disallowed under the EEOC and the Department of Labor. But now you can, in fact, in some ways, you're almost encouraged not to necessarily, at least not to have those people potential employees like that have it actually come to work. Even if you do hire them, it is strongly advised that you don't actually make them or encourage them to come to work, and you are allowed to withdraw a job offer if subsequently find out that someone has COVID-19 or symptoms of it. Again, I wouldn't necessarily encourage you to actually do it, but it is something that you are, depending on your specific situation, you're entitled to do it, and it may make sense in your specific situation. Okay,
I should just jump in. A conditional job offer is, for example, if you're hiring a truck driver and you say you're offered the job pursuant to a clean drug test, or conditioned on a clean drug test. So you can do that. If the test comes back positive, then you don't have to hire the truck driver. Same concept here. So.
Exactly. So now this is the question that they just mentioned. Essentially, can an employee refuse to come to work because they're afraid of infection? They only allow or guaranteed the right, or are absolutely able to do it if they believe that they are or will be in imminent danger. Imminent danger is defined. What that means, I'll just read it. It's any condition or practices in any place of employment which are such that a danger exists which can reasonably be expected to cause death or serious physical harm immediately, or before the imminence of such danger can be eliminated through the enforcement procedures of OSHA, which means that OSHA is able, they do, as Tom mentioned, they do these inspections, and they can fine and penalize businesses that aren't keeping compliance and things like that. So those are the procedures in mind. That is, as you can imagine, cause death or serious physical harm immediately, and that quickly before anyone can do anything about it. Even with COVID-19 and even with I'll say the infection rate, the death rate, that is still an extremely hard thing to, that will still be an extremely hard thing to prove. And so just most general work conditions don't. Now, if part of the job, the person's job is you're requiring them to, I'm making an example here, they're required to shake the hand of every single person that comes into a very heavily, populated office or something, maybe, but even for them, probably not, because of just how strict this is. So generally speaking, they can't really refuse to do it, and you are, again, generally speaking, entitled to let the person go over that. Depending on their job, I don't know that I would recommend it. If it's really not necessary for them to do it, to go into a physical location, if they can work from a home, as Tom mentioned, now is a good time to be as empathetic as possible, and to give people as much leeway as possible. But generally speaking, yes, you probably can let that person go, or if you have some other disciplinary process in place. Similar, along with those lines, can an employee refuse? Can can you refuse an employee's request to wear a medical mask? This has actually been, I've seen a number of stories of this from across the country, where the employers don't want the employees to wear a mask because they don't think it looks good. They think it makes the customers feel like they're in danger or that they're not safe or something like that. And so for that reason, the employers are refusing to allow the employees to wear these masks. Generally speaking, in most situations, you can refuse them that request. But again, as you should be as empathetic, we strongly recommend that you be as empathetic as possible. That you allow them to wear it if it makes them feel safe. The CDC did say on April 3rd that it's not required. The CDC, you can't really require much of anything, but they are strongly recommending that everyone wear actual masks or cloth face coverings, bandanas or whatever, in public settings, wherever. So along those lines, again, it's strongly recommended that you don't refuse those requests, but it's definitely happened a lot over the country over the last few weeks. I've seen about it a number of times, and generally speaking, you can refuse those requests.
Okay, quick question, just to confirm, and it might be reiterating what you said, but I've seen this question come in a couple times. Just to confirm, am I able to visit client homes with social distancing even though my state is still under shelter in place?
It would depend on your state specific, what exactly they have in place and what exactly they've said. I know in New Jersey, I can tell you that would not be allowed. You would not be able to do that. Virtually is fine, obviously, but in person, at least in New Jersey, I know you can't do that. And so I don't think I can answer that without, one, being licensed in your state, but two, without knowing more about what state you're in and all that. But you should take a look at, for whatever state you're in, you should take a look at the actual executive orders or laws that have been passed, and they should spell it out pretty clearly, what's allowed and what's not allowed. So I would strongly recommend taking a look at that.
Great.
Okay, so along the lines of that last question, can an employee refuse to work without a mask? It can in very specific situations. This is what I was saying. I said on this previous slide. I'll show it again. Yes, under most circumstances, these are essentially the circumstances where they can refuse. If let's say there's a specific condition about your workplace, or maybe let's say you are frequently sending your employees to a client's house or to a job site, maybe you specifically know that the person had coronavirus or that the area is at risk or had a high infection rate. If they asked you to do something about it and you are refusing to do anything about it, as long as they're asking in good faith, like they're not just asking just to clearly get off from work, they're asking because they have a legitimate concern about it. And then again, similar to the other things about there's the danger of death or serious injury. This is a little bit broader than that previous thing that we said, because you can just look at serious injury and the time requirements as well. So a lot of it has to do with what you know, when you know it, what the employee asks you to do, and why they're asking you to do it, for whether or not they can actually refuse to work without a mask. But again, we strongly recommend everyone to wear a mask as much as possible. I think that's it. Yeah, that's it. So I think we have to say we have a lot more questions, or?
Yeah, we have some questions coming in. First off, thank you so much for all of your knowledge. Somebody asked where they can find out more information, and I passed over the handy URL, covidcompliant.com, which is right there. Thank you, Scott. That is actually, I subscribe for their newsletter, and I have found the email updates to be not annoying, but actually really informative. And I've actually forwarded those emails on, and this is not a plug for you guys. It's actually really good information. And I really like the way that you present the information. It's clear, it's digestible, so I would check that out. Question for Scott: what will happen if you applied with 2 lenders for the PPP loan and are approved by both lenders?
Please don't take both of their money.
Right.
The moment you get the first one, you should tell the second one that you are withdrawing your application. If you actually took both money, and let's say you spent both sums of money, I don't know that they're actually going to go after anyone for this, but there are some potentially criminal liabilities with it. You are signing under, when you sign your application, you're signing under penalty of perjury, that you are only essentially accepting one of these applications. So absolutely, I encourage you to apply to as many places as you think you need to get the money. But the moment you get approved by the SBA, not before you even actually get the money from them, you should notify every other bank that you've applied with to withdraw your application.
I mean, unless you want to socially isolate in jail.
Please don't take money from both banks.
Okay, I have a contractor on a job site now in New York. He contacted me to finish up there, and client said, yes, I confirmed he will be masked and gloved and shoe protection. And I have no time to get that waiver. Is that okay? Ooh, not a good question to ask you guys.
Again, it's going to depend on the state and whether it's okay under the state of emergency there. If it's okay in the state, I would say that's fine, quite frankly, if it's already ongoing.
And generally, just to add on, Tom, I obviously agree with what he's just said, but these things are not you always want like a yes or no answer, but so much of it is situation dependent. And if you have all the protective equipment and everyone knows what's going on, but maybe you don't have the plan in place, you don't have the waiver, that could be, again, depending on the specific situations, that could be enough. It may not be, depends on, like I said, those specific situations. There could be a situation where you really need everything. And so that's why we think of it like a sliding scale, and we recommend as much as possible. But at the end of the day, there's only so much you can do, and there's only so much time you have to get these things. So do the most you can, and as long as you're doing something and you're doing it in good faith, you may be fine. You may be protected, but as much as you can do, the better off you'll be.
And a lot of people asked about specific verbiage and clauses to include in that waiver. I said, you guys specialize in this, so any document you have, your contract, any document you're creating, always have it approved by a lawyer. You cannot pay. That is the best investment in your business. So have it reviewed by an attorney. I know a couple of great attorneys named Tom and Scott. They're available. Again, their contact information is here, but that is so important. I think moving forward, a designer in our community started a document, and she's so kind, she shared it. But even if you use somebody else's document, you should still, you're in a different state, you're in a different county, you're in a different city, you should still have that reviewed by an attorney.
Right, and I've said before, and I like to say this, that nobody ever got rich by giving away their money, but they lost their wealth very quickly by not hiring a lawyer. So just be mindful, and especially if you're looking at legal documents, especially if you're combining legal documents. A lot of people will take samples from a whole bunch of different contracts. You can really get yourself into trouble when you start doing that. So strongly, whether it's us or someone else, strongly recommend you speaking with an attorney.
And Risa, I know it's a hard stop-ish, but one thing I forgot to say before about talking about getting your workplace ready is those of you who work in a large building, office building, you're going to have to go to your landlord and say, hey, I want those, the air handler filters changed. In our office, we have locks on the bathroom door that everybody touches all the time. They're going to have to come off. So don't forget that there's other landlord's going to have to do before you go back in.
Yeah. We have a couple more minutes. If it's okay with everybody in the audience, maybe we'll run a couple of minutes after. We do have another session starting at 11 a.m. PST, 2 p.m. EST, so we will need to wrap up soon, but let me get to a couple of these questions. I have clients in hire installer, so tile drapery directly, so it doesn't run through the designer or the builder's business, and I'm there supervising, again, project managing. Do I have the installer sign my waiver if she didn't hire them directly?
Sorry, who hired the installer?
The client, not the designer.
That would be belt and suspenders if you did. You can, but I don't think that you would have liability individually because of that.
Got it.
Because of
Got it. And then here, another one about the waiver. Do we need to have customers physically sign a waiver, or can we email and have a response touchless? Wouldn't that be protecting client and employee? I mean, yeah, you can do e-signatures, like that's totally fine. Would an email to a contractor with tips on how to keep yourself and our client safe suffice if you don't have time to get the waiver?
This is sort of.
That's on the bottom end of that sliding scale.
Yeah. And then somebody wants to know, what states are you licensed in?
New York, New Jersey, Pennsylvania, Connecticut, and Virginia.
Okay. Let me see. There was one other question right here. How do these recommendations come into effect when you do not have employees, but rather have independent contractors? And again, in California, 1099, it's a whole thing. So it probably depends what state you're in, right?
Yeah, I mean, I don't know if the independent contractors are coming into your workplace, but if so, you should still deal with that as if they were employees. In terms of them being out in the world, again, belt and suspenders, it wouldn't be bad to have waivers with them or agreements with them. But, you know, you can't be responsible for the independent contractors or your contractors going to homes and doing something that they should.
You have less liability, but not none.
Less liability.
Okay. Any closing notes that you guys want to leave us with today?
Don't spend your PPP money on things you're not supposed to spend it on.
Okay.
Don't take money from more than one bank.
And
have a plan and be empathetic.
Yeah, at some point we're going to come out of this. I think in New Jersey, New York, we're going to come out of it sooner than the other states. And you got to start planning for it now. You really should put together a good document, a good plan going forward. Recognizing, unfortunately, that we're probably, there might be a surge where we're coming back home again, unfortunately.
Great. And sorry, my last take, hitting it really hard, is just have all your documents reviewed by an attorney, and don't take stuff, because I've actually witnessed this firsthand. Don't take stuff and put it together and send it out there. That just is so important to protect yourself.
Not a great idea.
Cool. All right, well, thank you so much. We're just going to start with our next session in 30 minutes. We're going to really mix it up a lot and go from legal speak to a brand walkthrough. And thank you so much, Tom and Scott, for your hard work putting this presentation together, and definitely check out the covidcompliant.com website.
Thanks, Risa. Good luck, everyone.
Thank you.
Bye.